response to great uncertainty which EU nationals and their loved ones currently experience due to Brexit, and on numerous requests of my subscribers, I've created this special Your Rights to Remain in the UK After Brexit video series, clearly explaining your immigration rights to remain in the UK and lifting this veil of uncertainty off your shoulders. Hello, my dearest friends. My name is Svetlana Shlapak. I am the creator of this free ukvisasuccess.com channel and also a senior immigration solicitor based in London, UK. I won my first UK immigration law case at the tribunal back in 2003, which gives me over 15 years of experience in the UK immigration law field. I'm here to explain how the UK immigration system works and empower you by helping you gain control over your immigration situation and explain how you can apply information in these videos in practice. I've created a special mind map outlining how EU nationals and their family members can check if they qualify for indefinite leave to remain in the UK. This mind map is accompanied by the PDF guide clearly explaining each element of the mind map. These documents are completely free and can be used in less than 60 seconds. All you have to do is click the link below. Okay, now let us have a look at your next question. What are the suitability requirements of the EU settlement scheme? As an EU national or a family member of an EU national, when making your application under the EU settlement scheme, you will be expected to meet a number of requirements. And the assessment of any case always starts with checking if you meet the suitability requirements. It is very important for you to know what these are in order to make sure that you qualify before submitting your application. Suitability requirements are all about being a suitable person to remain in the UK. If the Home Office does not believe you are that person, the application may be refused. The UK government has its own definitions of suitability requirements, which are reflected in the grounds for refusal. There are actually two types of refusals, mandatory and discretionary. When the decision maker believes that one of the mandatory grounds for refusal applies to your application, and then he or she will have no choice, no discretion but to refuse your application. In other words, they must refuse your application. Whereas if you are caught by one of the discretionary grounds for refusal, the decision maker can still allow the application. In other words, they can choose to exercise their discretion in relation to a case. I personally see very little difference between the two because more often than not, the decision makers refuse the applications even if the applicants are caught by the discretionary grounds for refusal. Okay, which grounds for refusal are mandatory? Well, there are actually three mandatory grounds for refusal. The first one is when the applicant is subject to a deportation order or a decision to make a deportation order. The second ground of mandatory refusal is when the applicant is subject to an exclusion order or exclusion decision. And the last one is where the applicant is subject to a removal decision under the EU regulations on the grounds of their non-exercise or misuse of their rights. So basically, mandatory grounds for refusal are all about deportation, exclusion, and removal. Okay, so let us now consider the discretion grounds for refusal. The first one is in relation to the application and whether or not, to the applicant's knowledge, false or misleading information, representations, or documents have been submitted, including false or misleading information submitted to any person to obtain the documents used in support of the application, and the information, representation, or documentation is material to the decision whether or not to grant the applicants this leave under these rules. And finally, the decision to refuse the application on the basis is proportionate. So what is going to happen when you submit your application in terms of meeting the suitability requirements? Well, when you submit your application, it will be checked against the police and national records and the warning index. This process is also known as an initial assessment of suitability, where as a result of the checks, records indicate that, for example, the applicant has in the last 5 years received a conviction which resulted in imprisonment, or where at any time they received a conviction which resulted in the imprisonment for 12 months or more as a result of single offense, or where the applicant has in the last 3 years received 3 or more convictions, either custodial or non-custodial, unless they've lived in the UK for more than 5 years, or where the applicant is subject to an existing deportation or exclusion order, or the cases of interest to criminal casework in respect of a deportation or exclusion, for example, where the applicant is in prison and the case is awaiting deportation consideration, or where the applicant has entered, attempted to enter, or assisted another person to enter or attempt to enter a sham marriage, a sham civil partnership, or durable partnership of convenience, or where the applicant has fraudulently obtained, attempted to obtain, or assisted another person to obtain the right to reside in the UK under the EU regulations, or where the applicant has participated in the conduct which has resulted in them being deprived of British citizenship. Any of the above happens, the case will be referred to immigration enforcement, which will assess the case under the public policy, public security, and public health. And only after that assessment, a decision can be reached on the case. And just to remind you once again that a free mind map together with the PDF guides are available for you to download. These documents give you a bird's eye view of how EU citizens and their family members can remain and settle in the UK after Brexit. These documents are completely free and you can download them by clicking the link below this video. Have a great day, everyone.